How does a Cook Islands trust work? If you are concerned about lawsuits, a Cook Islands trust is probably going to be the best solution for you. So let's say you live here in the United States. You are the client. Let's not forget Texas. As much as Texas may want to be forgotten, it's still part of the United States. So you're the client and you're here in the USA. The first thing you're going to do is contact the tiny island country of the Cook Islands and set up a Cook Islands trust. Once your trust is established, the Cook Islands would then contact a bank over in Switzerland. The bank in Switzerland can invest in stocks, bonds, various different currencies, US dollar, Australian dollar, Swiss franc, British pound, the euro, and even crypto as well. So once the Cook Islands Trust is registered, the Swiss bank account is opened, you will then wire funds over into your Swiss bank account. The money is invested, you go about your life happily. Now, if you want some money out of the trust, you're not going to be able to take it directly out yourself. You have to first send a request over to the Cook Islands. The Cook Islands would then review the request, make sure you're not acting under any form of legal duress, and then they'll send a message over to your banker in Switzerland to release the funds, and then about a week later, you'll have money wired back into your account in the United States. Now, if a court ever orders you to make a request, you will of course comply. We always have our clients comply with court orders, and you will send that court-ordered request over to your trustee. So here we have the scales of justice. You've got a court-ordered request coming out of the United States. It's a request from the court. This type of request, the trustee will review, and they will see that you are acting under duress, and they will block that request. Typically, anytime you want your money out of a Cook Islands trust, you'll be able to get it out. However, if you're acting under legal duress, if you're only making a request because you've been ordered by a court to make a request, that will be blocked. This structure is what we use for 99% of our clients, where we register a trust in the Cook Islands, open up a bank account in Switzerland. Cook Islands is the best jurisdiction for registering an asset protection trust, and Switzerland is the safest jurisdiction in the world to hold your money. The combination of the two will give you the utmost peace of mind that your money is safe and protected. Good afternoon, good evening, and good morning, depending on where you are in the world today. I'm attorney Blake Harris, and today we will be discussing the truth about offshore case law. There's been a lot of misinformation circulating regarding offshore trust over the years. Myself and my team have done the research, and we're here to present to you the truth about offshore trust. Okay, so there's a list of 45 failed foreign asset protection trusts that has been circulating the internet for some time. It was published about 8 months ago, and the issue with this list is that many of these cases have been misrepresented in how they were presented. And this issue has been going on much longer than 8 months, but it was about 8 months ago that this list was published. A list like this is something that is likely to cause attorneys hesitancy in entering this field of practice. Myself, because of case law like this was being misrepresented, I was actually a bit hesitant to get into this industry. But years ago, I did the research myself and realized there was really no case law out there which gave a good reason for not engaging in offshore planning. So myself and my team, we did some extensive research on the list, and you won't believe what we found. We found that, well, first of all, the author of this list, he's a very well-known estate and asset protection attorney. His name is Stephen J. Oceans. On the homepage of his website, it even says that he's the most influential asset protection attorney overall today. So this is not a list that wasn't published to zero people. This is a list that was put out, and probably quite a few people read it. And there may have been a few people who this influenced their decision and persuaded them away from doing very protective offshore planning into doing some type of more
vulnerable type of planning like domestic planning. Now, Oceans has since removed this list after a bit of my encouragement, but as soon as he removed this list, he cited 3 other articles which can contain this list, which pretty much all overlap. I think there's one case that didn't, pretty much all overlap with the cases on this 45 list. The 45 list was, I think, meant to hurt the offshore industry, but actually not one of those 45 cases was actually a real failure of the trust. So again, the author has removed this list. Last time I checked, he still has references to this list posted on LinkedIn, and last time I checked, he still has a post up which references 3 other articles which contain essentially the same material misrepresentations of case law. So here's what we found. First of all, nobody has ever gone to jail for creating a Cook Islands trust. That is correct. Not one properly built, timely funded trust with an independent trustee has ever been defeated on the merits. Where people went to jail, it was for breaking the rules, never for the trust itself. Just like when you purchase a car, there are certain rules you have to abide by when you have that car. The same is true for when you set up an offshore trust. There are certain rules, and they're very simple to follow. Those rules are, number one, and I remember the rules under the acronym TICC, T-I-C-C. Don't be a tick and you won't go to jail. It's that simple. T stands for timing. Don't transfer assets too late. That's simple. If there's a threat of a lawsuit or a pending lawsuit or a judgment, don't transfer assets, or if you're going to do it, work closely with an experienced asset protection attorney who can guide you through how to properly transfer and document assets in so you don't get in trouble for a late stage transfer. Next, I stands for illegal. Don't do anything illegal. If you're committing tax evasion, if you're running a Ponzi scheme, if you're committing securities violations, creating offshore trust is not going to fix that problem. Don't do anything illegal. Next, control. You want to make sure that you have the right amount of control. Too much control at the wrong time can get you into trouble. Generally, what we recommend clients do is serve as the manager of their LLC, which owns all their assets. That LLC is then owned by their trust. We don't let the client serve as trustee. Now, if there's pending or active litigation, then we probably would have the client not step into the control position directly as manager of the LLC, but instead simply request the trustee take action. So essentially, they can still, through a request, have control their assets, but not the type of control that could land you in jail or get you in trouble with the court. And then the final C is comply. Always comply with the court orders. Anything a court requests, simply honor their request and comply. Okay, so we're going to start by going through some of the cases now, and there's quite a few cases to go through, so just understand that I'm going to be doing this with some speed. We're going to record this, so if you want to listen to it later, you can catch it at a better pace. But the biggest issue and the most common issues that we see as failures of trust, which aren't really failures of trust, it's failures of people just to act properly. Again, if somebody has a few bottles of wine and goes and drives their car and crashes the car, that's not a failure of the car, it's a failure of the user to use the product properly. So based on the documents, the cases that most squarely stand for don't transfer funds too late are the ones where assets moved offshore after a claim, suit, or judgment was already bearing down and settled. The strongest example is Advanced Telecommunications Network versus Allen. This is the clearest one. The Allens liquidated U.S. accounts and wired $2.2 million into Cook Islands Trust after a suit was filed and while a motion to freeze was pending. This was fraudulent transfer timing, not legitimate advanced planning. It produced repatriation orders and a contempt finding. Next is N. Ray Lawrence. Lawrence funded about $7 million into an offshore trust 2 months before a $20.4 million arbitration award he plainly anticipated. The eve of award timing anchored the finding that the trust was fraudulent and seller controlled, and he was jailed for contempt. Again, stupid people play stupid games, get stupid prizes. Bank of America versus Weiss. Elizabeth Weiss created the Cook Islands Trust the same day the arbitration notice was sent. They moved $25 million in. The blatant timing drew suits in Maryland, the Cook Islands, and forced a $13 million settlement. Again, this is not the trust even breaking. It is just putting pressure on the trust maker to settle. Bankfire versus Legend. Assets went into the Nassau Trust shortly after the bank won its judgment. This is a textbook fraudulent conveyance. The individual ended up jailed for contempt and agreed to turn over the assets. A few other worth mentioning: N. Ray Smith, the Cook Island Trust formed just 3 days before the order finalizing the judgment against him. He was pushed into involuntary bankruptcy. The results would have been the same had he had a domestic trust, or worse. FTC versus Ameridet Puke. Trust established less than 2 months after the FTC served CIDs in the teeth of the FTC's investigation. Don't mess around with trying to hide assets from the government. SEC versus Solo, the transfer to his wife, who then settled the trust, happened after the jury verdict but before judgment, and he was incarcerated for failing to recover them. Gilmore versus Asia City, trust created on the second day of arbitration, which would drag the foreign trustee into California court that found personal jurisdiction over it. Some other cases worth noting in the T category, the timing category, is Portnoy, funded when he knew his guarantee was about to be called. Brennan was a trust created near the end of his SEC trial. Rogan, he set up his trust months before a $64 million judgment. FDIC versus Lewis, especially characterized as a post-claim fraud on creditors. One interesting counterpoint is BB&T versus Billinger, where the trust was funded 7 months into the lawsuit, and the court still declined contempt. This is a reminder that bad timing invites fraudulent transfer exposures and contempt motions, even if it doesn't always guarantee the creditor wins those motions. And even when the creditors win the motions, never once has a trustee been compelled by a U.S. court to release the assets. Next, we have illegal. Don't do anything illegal. On the list, the cases that best embody don't engage in illegal activity are the ones where the seller's liability arose from fraud or crime in the first place, which is exactly why the trust came under such ferocious attack from government enforcers with contempt power and non-dischargeable judgments. Top representative case where the wealth itself came from illegal conduct. SEC versus Brennan, the single best example. His liability came from securities fraud, a $75 million disgorgement, and then compounded by concealing the Gibraltar Trust and bearer bonds from the bankruptcy court, earning him an actual criminal conviction for bankruptcy fraud. It's the only case on the list we could find with a stated criminal conviction, and it shows illegality both creating his debt and infecting the planning. U.S. versus Rogan, this case involves a $64 million judgment arising from a Medicaid fraud scheme. The government's FBI-backed pursuit unwound the Bahamian Trust as his alter ego. Fraud-based government creditors don't give up. We're again going to talk about FTC versus Affordable Media, the Anderson case. It's important because it comes up over and over as a way to discredit offshore trust. But if you understand the case, it doesn't in any way actually discredit offshore trust. In this case, the trust was funded with commission from a telemarketing Ponzi scheme, and the Andersons were jailed for contempt. The main illustration here is that ill-gotten gains can't be laundered into protected assets. However, in this case, they were held in contempt while they were standing in front of the court as a protector. That is very foolish. That goes back to my analogy of drinking a few bottles of wine and going for a drive. That is very foolish, very reckless behavior. It had nothing to do with the trust failing. Next, we have SEC versus Blazarian. And also with the Anderson case, again, the trust was never broke. Ultimately, a settlement was reached. So even with bad actors, late stage planning, doing illegal things, the trust still held. SEC versus Blazarian. The case involved securities fraud, producing a $62 million judgment that was litigated for 5 years and held non-dischargeable, followed by incarceration. Fraud judgments follow you forever, and regardless if you have an offshore trust, you're not going to escape a fraud judgment. In re Rensen. This was where Blue Hippo defrauded 50,000 consumers of over $14 million, yielding a non-dischargeable FTC judgment. Even a trust settled years earlier couldn't make liability go away. A few more to mention in this category. We've got SEC versus Solo and SEC versus Greenberg, both fraudulent security schemes ending in disgorgement, judgments, and contempt findings, incarcerations for Solo. The result would have been the same if they had a domestic trust. These are people committing illegal activities. These are not failures of offshore trust. Second best representative case where the illegality was committed during the proceeding. U.S. versus Thompson. Mr. Thompson violated an injunction, absconded as a fugitive, pled guilty to criminal contempt, then breached his plea agreement, jailed indefinitely. His crime during enforcement, not the trust, destroyed him. Next, we have Morris v. Morris. By her own account, incarcerated for indirect criminal contempt after failing to appear and becoming a fugitive. Next, we have In re Colborn and In re Portnoy again. False oaths and concealment of trust interests in bankruptcy, costing Colborn his discharge and putting Portnoy at risk, and lying to the bankruptcy itself is a crime-adjacent path to ruin. Though the line worth drawing for you is offshore planning done legitimately versus for legitimately earned wealth for unknown future creditors fares far better than the summaries in these structures funded with the proceeds of fraud, because fraud brings the SEC, FTC, IRS, and DOJ, and they litigate to incarcerate, not to settlement. So don't do illegal things. Next, we have control. Don't retain too much control over the trust. And as your attorneys, we will guide you and let you know what is the appropriate amount of control to maintain. We'll guide you to make sure that you don't break any of these 4 rules. Control is actually the hinge of nearly every impossibility contempt fight. The case that stands most squarely for don't retain too much control, and we're going to go through it again because it comes up again and again and again, is the FTC versus Affordable Media Anderson case. It is the paramount control case. The Andersons were trust protectors with the power to force the foreign trustee to repatriate. They had previously pulled over $1 million out to pay taxes and tried to resign as protectors only after the FTC exposed the role. The control is exactly what defeated their impossibility defense and landed them in contempt. Had they just not served as protectors or not just had those powers, they probably never would have been held in contempt. But again, play stupid games, win stupid prizes. In Ray Lawrence, Ms. Lawrence retained the sole power to appoint trustees plus the power to add exclude beneficiaries. This was the very control the court used to find that he could not reach the assets. Next, we have U.S. versus Rogan. Swore in an affidavit he had no control, but the FBI showed he had directed roughly $8.1 million in distribution to himself or persons he designated. The court found the Bahamian trusts were his mere alter ego, the funds available to creditors, the harshest control outcome we could find in the file. Next, we had, importantly, he kept sweeping control, including the power to remove and replace the trustee while making himself primary beneficiary, then compounded by disclosing only his discretionary interests and hiding the control powers. This is classic fraud, not properly disclosing to the court, lying to the court, doing illegal things. Yes, these can land you in jail, not having or properly using a Cook Islands trust. Barbie versus Goldstein, a seller beneficiary, he had the practical power to have the trust terminated and did, with the assets reverting to him. The summary states the rule directly: a properly structured offshore asset protection trust would never leave the seller the power to terminate the trust. Next, we have U.S. versus Grant. This I consider a self-inflicted wound. The court initially accepted her impossibility defense until she made transfers from the offshore trust to herself through her children's account, proving the very control she had denied. Next, we've got Brown versus Higashi. Funded and retained complete control over the assets while the Belize trustee remained a figurehead. The court reached the assets primarily for that reason. SEC versus Greenberg used the Gibraltar Trust as his personal account with substantial transfers over time, which destroyed his impossibility defense and produced contempt. The second best representative cases where retained control or benefit was a significant factor. Rush versus Sessions, the settler was entitled to receive and control the entire principal income offshore in name only. And then we've got Netsphere versus Barron. His ability to request $330,000 from the trust itself proved retained control, opening the door to the court's order and showing the trust wasn't fully irrevocable. Again, bad planning, not a failure of a trust. In Redson, self-settled discretionary trust whose trustee could distribute the entire corpus to him, making all assets reachable under Florida law. Satchin versus Brooks, the seller's broad beneficiary rights made it a void self-settled spendthrift trust under Connecticut policy. Brinstein retained control of assets and benefits with the corpus set to revert to him in 2005. Bank First versus Legendary kept the beneficiary use. The trust paid his Amex bills and utilities. Ulich, the Fifth Circuit affirmed he controlled the trust documents, which grounded the contempt and fines. The counterpoint that proves the rules. BPT versus Billinger, the one outright win, and more precisely because the creditors offered no evidence he retained control, and the court credited his testimony that he couldn't compel the trustee. Read against Anderson and Lawrence, the thorough line for your outlined rights itself. Genuine surrender of control is what separates a credible impossibility defense from a contempt citation. As experienced asset protection attorneys, we will work with you to make sure that you do not make the mistakes you've seen in these cases. And finally, for the last leg of the 4 TICC is comply. Comply with court orders. It's that simple. We always tell our clients to comply with court orders. If a client chooses not to, that is on them. It is not a failure of a trust or planning. So for this one, the single best case is Ulich versus U.S. It's essentially the proposition in case form. Ulich was held in civil contempt with escalating daily fines for failing to produce the Bahamian trust documents. But the moment he complied, obtained every request document, and turned them over, the court purged him of contempt. The trust's underlying assets were never touched. The case illustrates that the actual loss, not just comply, but always comply promptly, since the court assessed a $135,000 fine for the day he remained non-compliant without explanation. Even eventual compliance doesn't erase the cost of delay. A properly structured trust should let the settlor furnish all responsive information to a court while still protecting the underlying assets. Compliance and asset protection aren't intention defined, which is what gets you into trouble. A couple other cases on the matter. Again, Blazarian was incarcerated purely for refusing to provide a sworn accounting, and the court never reached the offshore corpus. Compliance would have kept him free and the trust intact. He was jailing entirely self-inflicted. Defiance of the order, not a trust failure. We also have Morris v. Morris. Mr. Morris was, by her own account, jailed for indirect criminal contempt for failing to appear in court, not for the trust, which was never set aside. The peers just show up and follow the court's process case, U.S. versus Thompson. Mr. Thomas jailed indefinitely for refusing to honor his court-approved plea obligation, the debtor's exam and power of attorney, not for the trust itself. So Ulich carries the affirmation lesson. Comply and you walk away with the trust intact, while Blazarian, Morris, and Thompson show the price of the opposite. In every one of them, the person went to jail for defying court process, while the trust corpus itself remained and survived. Also on the list were inflations. We found that there were 2 cases, or 4 cases, which only cited 2 cases. There were 2 cases which were duplicate, so there weren't even 45 cases on the list. Also, 2 of the cases, despite extensive research, we couldn't even find. They may not exist. Maybe they do. If you have them, please send them to us. Our team would be happy to review them. And if you have any other cases out there which have claimed to show the failure of a foreign asset protection trust, please send them my way. My team would love to review them and add them to 45fapt.com. Also, several of the cases didn't even have or involve an offshore trust. That is correct. On a list of 45 failed foreign asset protection trusts. Initially, the article was called 45 foreign asset protection trusts gone wrong, or 45 FAPs gone wrong, but the author has cited as 45 failed foreign asset protection trust. Of them, several of them didn't even include an offshore trust. These include Chatworth, Portnoy, Enri Sai, U.S. versus Buceller, Jerome Schneider case, FTC versus Fortuna Alliance, SEC versus Cook, U.S. v. Plath, Enri Megas Group, FTC versus Direct Benefits. There's lots of times, and this happens other places as well, people make up lists of failures of foreign asset protection trust, and the cases they're citing don't even include a foreign asset protection trust. I'll let you come to your own conclusions for what the authors of these lists are trying to accomplish. So after some encouragement, this list was finally taken down. Many months ago, I informed the author privately, actually last year I informed the author of this list privately that he had posted case law which was misleading. He did respond that same day, but indicated that he would not be taking corrective action. So I went and publicly announced on LinkedIn that his information was misleading, and he responded by admitting that he hadn't read some of the cases. However, negligence of your representation is no better, no worse than intentionally misrepresenting case law. Either way, it harms the public, and the public should be presented with true information when it comes to doing their asset protection planning. Some may choose to work offshore, some may choose to work domestic, but either way, the client deserves nothing but utmost transparency with the case law. Again, this list has been removed. Last I checked, the author's references on his LinkedIn to the list still remained, and as soon as he removed this, he went and posted another LinkedIn post which linked to 3 other articles which contain many of the same cases and many of the same misrepresentations. Because of this, it appears that he's intentionally trying to disseminate false information. And so I've had no choice after informing him of the misrepresentations and giving him a courtesy warning that he has been reported to the bar. He has claimed that this is a petty matter, but 45 cases miscited, then linked to 3 more lists, which pretty much cover the same misrepresentations. It's not petty. It is, in my opinion, a serious misrepresentation. The cases, so here's some things we were observing from the author on LinkedIn. By the way, this whole conversation is taking place on LinkedIn. I would encourage you to go to LinkedIn and follow me on LinkedIn. I'd also encourage you to go to Steve Ocean's page and follow him as well. He has been very reluctant to comment on anything on my page. He's even taken screenshots of what I put on my page as opposed to commenting on it. He takes screenshots and puts it on his page. I've also noticed where he deleted and blocked a user who posted something adverse to what he was saying. So I'm having trouble getting this in front of my audience, but if you want to go follow me, I am posting about this on my side and you can gauge there. If you want to follow Oceans as well, you can see the dialogue between me, a lot of his longtime supporters who I imagine have not read the case law and done the analysis we have, but I'm encouraging them to, and hopefully 45fap.com will open more people up to the truth about case law. But if you would like to see the dialogue between the two of us, you can also follow Stephen J. Oceans on LinkedIn. But please follow me. I'm going to keep you up to date about future case law that comes out, continue to dispel rumors. As I may have mentioned at the beginning, I'm the managing attorney at Blake Harris Law, the nation's largest law firm exclusively focused on offshore asset protection. I'm also the manager of a co-founder and owner of Atlas Trust Company in the Cook Islands, along with my close friend Marcus Almeida down in the South Pacific. I've also become an industry watchdog, and I've helped to identify bad actors in the field, such as Kevin Wessel, also known as a business guy who runs Lawyers Limited and Asset Protection Planners, who I filed a federal lawsuit against and filed a Florida bar complaint against and exposed him on the offshore watchdog. Oceans, though, has been a little bit different in how he's reacted. And what's interesting is instead of addressing our legal arguments or reviewing the relevant cases, he's resorted to personal ad hominem attacks, going after me personally. It appears he's attempting to deflect from the core issues by making false claims that I'm threatening him, which I'm not, by belittling my professional standing and suggesting others will refuse to work with me for exposing the truth about the case law. Furthermore, as a father myself, I find it a bit unsettling how he frequently references his younger daughter, which appears to be another distraction technique. We're dealing with seems to be a clear effort to misinform and shift the focus towards domestic planning. Rather than engage in a direct debate in front of my followers, again, he screenshots my content and proceeds to make generalized personal criticisms to his own audience. I have invited him to a live debate to defend his position, but he refused. And again, I've since seen him delete a comment and block someone who's put up an opposing view. I'm continuing to carry forward objectively and point out the errors in his positions while ignoring the personal distractions. So regarding the award that Mr. Oceans posts on his homepage, I do want to point out that the most influential claim on his site is supported by a ChatGPT transcript, not an organization, not even an individual. The document says so itself, a copy of a conversation between ChatGPT and Anonymous. There's no methodology, no way to know who ran it, and no way to reproduce it. It also opens up by saying there isn't a single university-agreed most influential asset protection attorney. The ranking inside it is the part worth reading. It splits influence into three categories. On the impact of case law, meaning what actually holds up in court, it puts him fourth of 6 behind Jay Atkinson, Barry Engel, who was my mentor many years ago, and Gideon Rothschild, describing him as more forward-looking than litigated. His legislative influence is real, and the transcript ranks him first there. But this is an award. But this isn't, in my opinion, really an award. It's a chat window. And on the courtroom question, it ranks him fourth. The initial bar complaint that I've filed mentioned, number one, the misrepresentation of case law. Number two, this ChatGPT award, which I believe is misleading to consumers who don't understand ChatGPT very well. And number three, it also mentions his defamatory or potentially defamatory statements against me. I then filed an amended complaint about 2 days later, asking the bar not to focus on the false claims of me threatening him or what I believe are defamatory statements, and not to focus on this award. Instead, I asked the bar just solely to focus on the misrepresentations of case law. I still stand by all three of the points mentioned in the initial bar complaint, those that are still, I believe, accurate. However, I'm not asking the bar to expand resources investigating those matters. The only thing that I want to straighten out is the misrepresentation of case law. And if Oceans can simply go through his LinkedIn, clean up all the misrepresentations that he has posted himself, that he has referenced, or that he's linked to other people's articles that misrepresent case law, then there will no longer be an issue here. There may be others in the industry who I need to correct for misrepresenting case law, and I will continue to fight to provide transparency to consumers of asset protection services. Because at the end of the day, an offshore trust really sells itself. There's never actually been a failure of a 45 of a foreign asset protection trust. There weren't 45 failures. There weren't 24 failures. There weren't 20 failures from the research me and my team have done. And I would venture to say that we have done more research on the subject than probably anyone else living, probably anyone else since Barry Engle passed many years ago. There are zero failures of foreign asset protection trust. A failure means a U.S. court broke the trust or forced the trust to hand over the assets. That has never happened. Someone punished for ignoring the rules isn't a failed trust. It's a client who didn't follow them. The bottom line, zero defeats in the merits. That's the FAPT track record. But let's compare that to domestic counterparts. There have been multiple failures of domestic asset protection trusts. And to the best of my knowledge, this line should be clarified, but to the best of my knowledge, every time ADAPT has reached a final appeal, it has lost. If a client can't afford a car with working brakes, you still don't sell them one without brakes. Steering someone into a structure that loses on appeal is no different. It is my stance that creating a domestic asset protection trust is malpractice. And I predict we're going to see more people join my point of view in the years to come. As more domestic trusts fail, clients are going to be upset. They're going to turn around and sue the attorneys who set up the domestic trust. And then it's going to become very well known that domestic asset protection trusts are malpractice. So I hope you've enjoyed today's presentation. My team and I have spent quite a bit of time assembling the case law here, and we've put it all on a website for you, faptfacts.com. If you are looking to set up an offshore trust and you've been hesitant to because you've heard they failed or that you might go to jail, contact my law firm. We're happy to set up an initial consult with you where we can talk to you about the benefits of an offshore trust. We can talk to you about the drawbacks of an offshore trust, but you're going to get the honest information from us about offshore trust. If you are an attorney or otherwise promote offshore trust, you should save and bookmark FAPFacts or 45fap.com. FAPFacts is a website dedicated to providing transparency in the asset protection industry. We want people reading these cases. We want people to know the truth. And when somebody comes to you and says, I've heard that foreign trusts fail, or there's a list of failures of foreign trust, you can respond with FAPFacts. If there's any case that you've ever come across that anyone ever brings you and they say it's a failure of a foreign asset protection trust, check FAPFacts first. But if it's not on there, send it to me. Me and my team will research it and we will present the results. And if it is a failure of a foreign trust, we'll be the first to let you know. But if it's a case like those on the list, which didn't involve a trust, duplicate entries, couldn't even be found, or fell into one of the TICC behavior, we'll also identify it as that as well. Okay, so we've got a few minutes for questions. Does anybody have a question for me today? Looking out at the audience. Okay, our offshore trust was set 10 up with deeds of trust to encumber 2 properties in Vegas. We were open or to appear at trial witness court to overturn the deeds did not monetize by a bank. That question's a little bit confusing, but it sounds like you may not have done proper planning ahead of time. When it comes to real estate, you want to put liens on the property as far in advance as possible and use a legitimate lender. Don't just do fake liens. Fake liens could be considered wire fraud. There's a strategy some people do where they use a line of credit as a lien, which is a more economical way to set it up, but it's not going to hold up as well as a properly documented loan will. Is it legal to make an offshore trust? Did you watch the presentation? Yes, it is absolutely legal to make an offshore trust. It is legal, it is ethical, it is smart, and it's a business that's been in place and operated by lots of very high integrity people for over 40 years. It is absolutely legal to make an offshore trust. Do you offer consultations? Absolutely. Visit BlakeHarrisLaw.com. Give us a call or fill out a contact form. We'll get you scheduled with a member of our team very shortly to discuss your asset protection needs. I'm Attorney Blake Harris. I hope you've enjoyed today's presentation on offshore asset protection. Again, visit FAPFacts.com or reach out to my website at BlakeHarrisLaw.com to schedule a consultation. Thanks so much for your time today. If you're watching this, you built something worth protecting, and now you want peace of mind that it won't be taken away. I'm Blake Harris, managing attorney at Blake Harris Law, and I will explain how to get the best asset protection. There are two options in asset protection. Protect your assets here in America, where courts have pierced those structures repeatedly. The other option is creating an offshore trust in a jurisdiction such as here in the Cook Islands, where a U.S. court can't pierce your trust. Your Cook Islands trust will be paired with an offshore bank account in Switzerland or another reputable banking jurisdiction, which will help grow your wealth through diversified investment options. Two things you may have heard that aren't true: that a Cook Islands trust will land you in jail, and that the IRS reporting requirements are complex. Neither of those statements are factual. It's fully legal, and with proper guidance, it's very simple. Here's what no other attorney can say. Blake Harris Law is the nation's largest law firm focused exclusively on offshore asset protection planning. I'm also the only known U.S. attorney licensed by the Cook Islands government to own a trust company there, Atlas Trust Company. My law firm and Atlas charge flat fees for the entire engagement, never hourly. You'll know the full cost before you decide anything. And my law firm has likely established more Cook Islands Trust over the past few years than any other law firm in the world.